Yes, Miss Sutton.
Good afternoon, my lords. As you're aware, I appear on behalf of the first intervenor, Professor Celia Kitzinger, in this appeal with my learned junior who sits behind me, Miss McNeill Walsh. My lords, you're aware that Professor Kitzinger is the co-director of the Open Justice Court of Protection project, and you know from her witness statement that this is a small voluntary organisation which began in June 2020. It's run by 5 members of the public, none of whom are lawyers or journalists, but who take an active interest in promoting open justice in the Court of Protection. They are members of the public and they have no special status in the Court of Protection. The documents, my lords, that Professor Kitzinger has provided to you to assist in this appeal, you have the brief statement in response to the appeal, which is found in the core bundle at 76, the skeleton argument in the core bundle at 127, her witness statement again in the core bundle at 223, and finally the supplemental skeleton argument core bundle 243. My lords, having seen the arguments develop this morning, I now intend to structure my submissions in 2 parts. I will speak to the individual grounds of appeal, responding to my learned friend, Mr. Rutkin, King's Counsel, where relevant, and I can confirm at the outset that we do agree with Mr. Rutkin that the guidance went astray insofar as paragraph 36.5 of the judgment of Mr. Justice Poole conflicts with rule 5.92 of the Court of Protection Rules 2017, but the consequence of that, we differ from what the appellant says should happen. Insofar as the second point of submissions, moving away from the 6 grounds of appeal, I will structure the submissions in terms of the future and what assistance Professor Kitzinger can provide in terms of guidance for future cases. Before I turn to the grounds of appeal, my lord, can I just deal with a few preliminary matters by almost way of housekeeping, I suppose, that were dealt with in the oral exchanges this morning. Insofar as what Professor Kitzinger received, it's dealt with in paragraph 2 of the order of Mr. Justice Poole of the 14th of July. The reference is the core bundle 48. Yes. And what Professor Kitzinger received by the 5th of August 2025, effectively it was outstanding position statements. It wasn't a wholesale tranche after the event because there were documents that were provided piecemeal by the other parties in accordance with the permissive direction.
Because they were willing to do so.
Quite. So the outstanding documents that were received by the 5th of August were from the appellant and from the ICB. She was already...
Sorry, just a moment. So, page 48.
Yes.
So the additional receipts were the appellant's
and also the Integrated Care Board, who'd also objected.
Right, so the skeleton arguments.
Yes.
And so there were in those days 1, 2, 3, 4, 5 participants. And so one might suppose that in relation to each of the 4 hearing dates, the collection consists of 5 skeleton arguments. I mean, the exact number doesn't matter, but just to get a sense of it, viz. Some 20 skeleton arguments or position statements were by degrees gathered by means of the orders.
Yes, looking at the participants, if we take, for example, page 47, which is the actual order that's subject to appeal, the applicant there, so the ICB, didn't disclose any of the documentation until the actual direction was made by the judge. Mm-hmm. AB, who is the first respondent, so that's Mr. Gardner through the official solicitor, those documents were provided incrementally in accordance with the permissive directions. The second respondent was the trust. Some of those documents were provided, but the trust didn't take an active role throughout the longevity of the proceedings.
I missed something that you said. Could you just say what the position of the trust was again?
The position of the trust is that they provided some of the documents when they were present at the hearing. by reason of the issues as they developed. My understanding, again, I wasn't at first.
Right, so they didn't have a full set of... Okay.
That's right, but the nub of this, my lord, is that the persons who did not want to disclose to Professor Kitzinger were twofold. It was the ICB as the applicant, and it was the appellant, who we see referenced as CD. So the...
Right, whereas EF did provide.
She did, my lord, and as did the official solicitor, as indicated.
Right, so...
Oh, I'm so sorry, I'm reminded. This goes to the alphabet soup.
The other way around, isn't it?
It's the other way around.
Thank you.
So EF is the appellant. I'm grateful. My lord also inquired in terms of how the witness statement of Danielle Huntington was provided to Professor Kitzinger and indeed referred to within her witness statement. That transpired because Professor Kitzinger was formally made an intervenor into the proceedings in late September, and she formed part of the submissions made to the learned judge in his final judgment. So
Right,
when
so that was no informal process.
Absolutely
it was,
not.
As an intervenor.
Quite. So that's how the document got to her.
And just out of interest, as an intervenor, did the judge give any directions about what documents she should have? Did the judge limit any of the documents that she should have as an intervenor?
No, we had I represented Professor Kitzinger in that hearing. There was a court bundle and everybody was privy to the same information to make those arguments, yes. And that's why the witness statement...
Can we just confirm the situation about that particular point? I wonder if... I'm just checking.
Oh, is there movement behind me, my lord?
There was movement behind you.
As an intervening generally. Intervening form.
What I'm being told is that we didn't have the whole bundle that had been provided, for example, for the purpose of the validity of the advance decision.
Yes.
There was a select bundle for the purpose of determining Professor Kitzinger's application,
Yep.
and it was those documents that all parties were privy to, but we certainly didn't have disclosure of everything that had been operative
Well,
from
that
day
makes
one.
perfect sense now.
The final preliminary point is just to touch upon the applicability.
Sorry, before you leave that,
Certainly.
no reason that you should know, but this happened to be a situation where the number of people who at that stage were asking for disclosure were one or two. Do we have to keep an eye on the fact that there was also disclosure to the gentleman from Dignity in Dying? Do we know anything about that?
It was part of the permissive direction. I don't know if you
Right, where do
received
we-
those documents.
Do we have that
Do you have the
direction? Where can we find that?
Supplementary bundle 232.
232, paragraph 8, my lords. And this was the last permissive direction before we got to the actual direction mandating disclosure. And that's
Sorry,
where we
I
see-
misstated the name of the... It's Compassion in Dying.
Yes.
Right, so that was permissive, not mandatory.
That's right, my lord.
As at the 30th of June.
As of the 30th of June, that's right. And I'm told by Miss Scott that there was no request by Mr. Moss for the official solicitor to disclose any documentation to that person.
Right. So for our practical purposes, particularly as Mr. Moss is not here in the court, the appeal bears on the 15 to 20 documents that were gathered as a result of the combination of the judge's orders, and we're going to have to decide in the light of what happens about the appeal, whether any order needs to be made in relation to those, and you'll come to that
Certainly.
at whatever time you think best.
Certainly.
Thank you.
But just for absolute clarity, insofar as the mandatory direction, that was solely against Professor Kitzinger. So the documentation from all parties collectively, when we look at paragraph 2A at page 48, it was only Professor Kitzinger who had those documents in totality in accordance with that order. I know not about Mr. Moss and what he had previously.
Yes, and of course the appeal isn't against the earlier order.
No, quite.
Yeah. All right,
the whole
I'm sorry
point.
to have been slow to get there, but it's just as well to make sure that we're all seeing the same thing.
No, of course, of course. The final preliminary point, my lord, I was going to make was just about the applicability. I say just about the applicability of open justice in the Court of Protection, like it's a minor thing, but to deal with the point that was raised by my learned friend. It's addressed in our supplementary submissions, and I think all I need to say is to reiterate to my lords the conclusion that we reach at paragraph 18, and it's in the core bundle at 254, and it's simply to reiterate my learned friend's point that open justice is not just black and white. There are clearly shades of grey, as to use Mr. Rutkeen's analogy, how the tap is turned on. It's dependent on the facts. So we are not simply looking at private and public hearings in the context of what happens every day in the Court of Protection. It's open hearings, open reporting, whether there's an open judgment, and open documents in the context of what we're looking at today with position statements. And I agree entirely with my Lord Justice Coulson in so part as the interchangeability of the terminology. In the Court of Protection, it's position statements, skeleton arguments, written openings. They all constitute important documentation that goes before the court. So I take no point in terms of the language used, but it's not simply about public and private hearings. It's about, as I said, the shades of grey in between. Clearly on the facts of the specific case, having undertaken the appropriate balancing exercise that would need to be done by the individual judge. I say no more in relation to the applicability of open justice. If I may, my lords, turn to responding to the individual points of appeal. And I am going to take it methodically, if I may, instead of jumping around. Without any discourtesy to my learned friend who said jumping, I find it easier to structure it that way. Ground one, my lords, is unjust because of a serious procedural irregularity. We deal with this in writing at page 76 of the core bundle, paragraphs 3 to 4. That's the only reference that we make to this particular ground. And I think...
Sorry, can you give us the page reference again?
It's page 76.
76.
And it's paragraphs 3 to 4.
Thank you.
And the point I would like to emphasise in relation to ground one, my lords, is that this was a case management decision insofar as the direction of position statements, and my Lord Justice Peter Jackson in the Hinduja case reiterated at paragraph 47, and it's in the authorities bundle at 1317, that the threshold for an appeal court interfering with a case management decision is particularly high, and I don't need to remind you of that, I'm sure. But what Professor...
I'm not sure what the threshold is for a case management decision interfering with a case management decision.
I haven't gone there.
I mean, this was a slightly unusual case management decision in that it wasn't the first off decision, it was a decision to go back and review the previous one, but we all know what we're talking about.
We do. And insofar as the application was made, Professor Kitzinger had not at any time made the formal application in the way that she had. There had been oral applications made at hearings, but when the judge wanted to look at it comprehensively, there were specific directions that were made by the judge for Professor Kitzinger to put what she wanted to say in writing. So the suggestion by my learned friend that this was thrust upon the parties with surprise, there was a very clear process in which there was an ability to look at what had been said, to respond accordingly, and to make such submissions to the judge as were considered appropriate. It was almost said as this was off the hoof, and it was done very quickly. There was a staged process that Mr. Justice Poole put in place to enable the parties to look at
As I understood it, though, but correct me if I'm wrong about this, Mr. Justice Poole, when he gave that direction, contemplated that all that he was expecting to see were position statements that dealt with the 30th of June hearing. And it was only when Professor Kitzinger put in her position statement in which she said, well, actually, I'd like all of the previous position statements. That was the first that the other parties knew that the scope of the request had expanded. Is that right or wrong? That's certainly how I'd understood it.
It's right insofar as Professor Kitzinger, in not having all of the other position statements, when she put it in writing, said, I would like that which I have not been provided. And the judge indeed indicated surprise, because on his understanding they had been provided. But I don't think it's a difficulty in relation to the process, because the parties weren't being told, we want all of the documents, and then they had to respond orally, and there was an extempore judgment. There's a period of time for them to respond, and the appellant was represented by leading counsel and junior counsel throughout, so there was an ability to contemplate the matters that were put in writing by Professor Kitzinger carefully in advance of there being a deliberation and a detailed written judgment by the judge.
Sorry. Do we have the order that directed that? Forgive me. I'm
We
sure
do.
you have seen it, but I can't just remember where I found it.
We do.
Is it the...
If we look, my lord, at the directions that are set out at page 233 of the supplemental bundle, it's within the body of the order dated the 30th of June.
Thank you, yes.
And paragraph 10 is the relevant start of the process, as it were. Permission to Professor Kitzinger to file any submissions on disclosure of skeleton arguments to the public by 4 p.m. on the 1st of July, limited to 2 sides of A4, trying to establish proportionality there.
Yes.
And then paragraph 11, responses to be filed relatively quickly. I can see that, responses by the 2nd of July.
That was really what was in my mind when I was asking the question, because I think you gave me to understand that the parties would have had plenty of opportunity to reflect on the fact that Professor Kitzinger had expanded the scope of her inquiry. They had effectively 24 hours.
They had 24 hours, but I would add that although there's limitation to 2 sides of A4, when we see the written submissions that were provided by the appellant, there's some 15 pages and they go into...
But because I think, as they said in those submissions, we didn't appreciate that what was in issue were all these previous position statements, and that's why they decided that they ought to put something more comprehensive before the judge. Is that right?
Absolutely, that is the chronology, and I don't shy away from it, my lord. All I'm seeking to emphasise is that this wasn't an oral application that was made at the conclusion of the process, and there was an expectation for the parties to immediately respond. And of course, if the direction as of the 4 p.m. on the 2nd of June was not something that could be accommodated, there would have, of course, been an ability on the parties to write to the judge and say, please may I have a little bit more time in light of the information that we've had from Professor.
It is, I mean, it's nobody's fault, but it's a funny order, this, of the 30th of June. When one considers what's being considered on the first 2 pages, and then what's being considered on the 3rd page, and to contemplate that at a time like that, the court was concerned with position statements and 24-hour turnarounds and so forth. As I say, it's just what happened, but it seems, at least to me, to speak for these sort of things being dealt with when there's time to deal with them, and not at times like that. Before I forget, could I ask if Ms. McNeill-Walsh would kindly at some point just put on one side a list of the documents which Professor Kitzinger did receive, because I mean we know how many roughly they are, but whose document, skeleton argument of the so-and-so, dated such and such, received on such and such date. I think it would be helpful if we just had a list of what we're talking about, seeing as the appeal is in the end about those matters.
Very well, that will be done. I think the position that we got to insofar as the submissions on ground 1 is that there was not an issue now taken that it could not to be done, it was whether it should be done, and looking at why it was necessary to provide the position statements in the manner that my lord identifies at the end of a very sensitive process. The answer is set out within the judgment at paragraph 28, and it's in the core bundle at page 63. And what's set out at paragraph 28 by the learned judge is that none of the key issues, other than contact, were addressed in open court. Without sight of the parties' position statements, observers could not know what issues remained in dispute at the start of the hearing. So there is an explanation as to why it was felt necessary to consider the matter at that time. And the purpose of open justice, it's not as narrow as the appellant submitted prior to lunch. It was submitted very categorically when you asked my learned friend, is it about the way that the court makes decisions? Yes, but actually, if one looks at what is set out in HMP, citing Dring, and it's within the bundle of authorities at 1528, and of course this is the HMB case where the Lady Chief Justice, Lord Justice Warby and Lady Justice King gave a joint judgment, it's clear that it's twofold. It's not simply to scrutinise the way in which courts decide cases, of course to provide public accountability and to secure public confidence, but the second point that's set out in HMP that's referenced in Dring is to enable public understanding of the justice system. Whilst the court recognised that its identification of these purposes might not be exhaustive, the core aim is to ensure appropriate transparency for the work of the courts and tribunals and the judges who sit in them. So it's not as limited.
It's not to aid public understanding of how people in distress react to their family problems.
No.
That's not one of the purposes on anybody's list.
No, that's absolutely accepted, my lord. Professor Kitzinger says that the application was made for the purpose connected with the open justice principles, so it was in line.
That's right, but there's also a time element in this. And in making these points, I would wish to stress that these are not in any sense partisan points. It's situations arise. They don't always arise in the way one would best hope. But if anything comes of this appeal with its narrowed issues, must surely be to make sure that nobody, from whatever angle they come from, should be faced with the situation of having to think about things like this at a time like that. This is completely inappropriate.
Well, of the reasons for the application for disclosure, they're set out in the supplementary bundle within the submissions that were made by Professor Kitzinger at paragraph 3.
Page?
It's page 235 of the supplementary bundle. And within paragraph 3, Professor Kitzinger outlines in her submissions to Mr. Justice Poole that the case is of legitimate public interest. It was held in public subject to reporting restrictions, and as a public observer, it vividly displayed for me the way in which the law, in the shape of the Court of Protection, intervenes in what many people consider the private sphere of family life. So that's drafted without any assistance of a lawyer, but she is providing some clarity to the judge as to why she is asking for the documentation. And I take my lord's point about the timing, but the reference in terms of the content of the reasons is in paragraph 3. And I'd also ask my lords to look at paragraph 11, which is at page 239. And what Professor Kitzinger says is, I've explained that I'm seeking disclosure of the position statement in order to better understand how this case unfolded over time and the shift in position the parties took on the different issues. So again, there is a want to try and explain from her perspective why it's being done. And on point 2 in paragraph 11, she says this: in my role as an educator and as author and editor of the Open Justice Court of Protection project blog, which serves to inform and educate the public about the law, both statutory and case law as applied by the judges in the Court of Protection. And she goes on to talk about the blogs that she provides. So in her view, that type of information is providing an explanation to the judge as to how the open justice principle is being achieved by the documentation being released to her and understood and distilled. The last point to make in relation to this aspect is it was submitted by my learned friend that it was not appropriate to deal with matters in the time that it was, because the court didn't make any orders. I think from what we can see in the final order that was made, that's not correct. There were a number of orders that were made. It wasn't simply a recital provision within the last order. It starts at page 230, and this is the order of the 30th of June. So on page 231, my lords, yes, there's the recital in relation to the validity and applicability of the advanced decision to refuse treatment, but when one looks then at the body of the order, there are substantive orders that are made under the Mental Capacity Act insofar as accommodation and care are concerned. So that was a specific order made by the court. And then paragraphs 1 down to 5 deal with the deprivation of liberty provision in line with the order that was made under sections 4A16 of the Mental Capacity Act, in particular for that provision. Then there's reference to an order to move to palliative care in paragraph 6. That was an order made pursuant to section 24(1). And then we've also got a contact order that's set out in paragraph 7 in relation to a section 16 final order for contact between Mr. Gardner and his family. So it wasn't as if there was an end.
Those were agreed?
Those were agreed matters, yes.
Yes,
But
so it wasn't a court deciding it, those were agreed. Because that's in the recital, on the parties agreeing the terms of the contact order.
yes, but insofar as the deprivation of liberty order, that has to be an order that's made by the court, authorising the deprivation of liberty of the accommodation and care in the patient's his best interest. So there needs to be formality, albeit that it wasn't a contested matter that led to a formal determination by the judge. And in terms of the sensitivity of the information, again, which I don't shy away from at all, and whether this is simply a general interest as opposed to a public interest.
If you're moving away, just while we're on ground 1, which I think we are, at least
Yes,
understood we were, but what was being said about that was that, my words not Mr. Ruck-Keen's, but that mining the archive for information about an advance directive that was no longer an issue before the court by the time we came to June, was not a proper use of the court's power to give effect to open justice, because, as you've been gathering, there's an issue as to whether a lot of the matters that ended up having to be decided had anything to do with that. It was an issue that arose, it was an interesting issue, but it fell away. Why should it be appropriate in those circumstances for that to be, so far as the family was concerned, raked up by the production of old position statements, which were no longer of anything other than historic interest to the parties. And so that's the case that's been put, as I understand it. And on ground one, it seems to me you have to meet it. So how does that work?
So we say it's the second point that was identified in HMB cite in Dring. It's to enable public understanding of the justice system. What is being...
Why is there any need for any more understanding than what I've just recited? I mean, if this had been a decision which was being taken at the time, maybe the judge might have made an order for mandatory disclosure, maybe he would not have done. But I'm having to look at the order that was in fact made, which was made after the event, retrospectively, and quite understand, because Professor Kitzinger is, as one would expect, completely frank about why she wanted to understand that. But what I'm putting to you is the question of why she should expect to be entitled by an order to see that element of the matter once it had no longer become a matter for judicial decision.
My Lord, I go back to what was said at paragraph 28 at page 63 and rely on what the judge said, that none of the key issues other than contact were addressed in open court. And without sight of the parties' position statements, observers, so Professor Kitzinger, could not know what issues remained in dispute at the start of the hearing. It's the development of the case and an understanding of how
Yes, but by the time he made his order, everybody knew what the issues were, and in fact they had narrowed. And so and he's talking here about the hearing, the final hearing that he conducted in respect of welfare. That
Yes.
is the hearing that is in question.
Yes, and he's going into detail that an understanding of what the parties' positions had been on those issues and how the parties had moved their position on the first day of the hearing. That's what the judge says at paragraph.
Then you're going to have to meet the point that, at least as it appears to me at the moment, the public, as represented in this instance by your client, may very well say that they need to understand how courts decide cases. But why does that encompass them having to decide why individuals may make decisions about their stance in the litigation? Why does that? When the result of the changes in position is that there isn't anything for the court to decide.
My instructions, my lord, is that there was a real issue of delay in this case between the time that the matter was brought to the Court of Protection and the time that the order was made, in circumstances where the validity...
That's not a ground that she put forward in her submissions.
No, the grounds that
So
were...
that's a new point.
The grounds that were put forward in the submissions...
Flailing about a bit. That's a new point, isn't it?
Yes, my lord. The points that I've raised with my lords this afternoon, it's paragraph 3, legitimate public interest, and paragraph 11, which sets out the explanation.
Yeah, but now you're talking about a delay.
Yes, I'm told that that was certainly in her mind when making the application, dealing with the timing aspect that's been raised today. But I appreciate, my lord, that it's not within the written submissions that went before Mr. Justice Poole, before he made the decision.
Let's let that pass for a moment. Why would that have made any difference? I mean, there was a family dispute, particularly a difficult one, and as a result of that, no doubt things took longer to decide than they otherwise would have done. I don't see what's difficult to understand about any of that, in terms of understanding how the court works. Of course, it may be interesting to understand how the individual parties approached matters, but why is it of public interest?
Well, the specific issue was whether an advance decision was valid. It was subsequently not challenged in terms of the validity, so that meant that the withdrawal of life-sustaining treatment, which ultimately was agreed by way of the palliative care plan, that was a delay. That, I think, is what the note is that I'm being asked
I can
to raise.
understand, because I think I've read somewhere a reference to the fact that decisions about advance directives are few and far between.
That's right.
And so no doubt, as anybody who's interested in this area would hope that there were more decisions about advance directives in order to shine more light onto this aspect of it or that aspect of it. But that doesn't mean that one is entitled to have access to papers in cases where it's not decided, does it?
I mean, what the judge says at paragraph 29 is that the case involves an issue of considerable public interest, namely the efficacy of an ADRT, including life-sustaining treatment. So that is something that Professor Kitzinger had raised, and that is something that is analysed and met by the judge at paragraph 29. I don't think I can take the matter further. I've provided the 2 points of specificity within the written submissions that were made by Professor Kitzinger to the judge at the time.
Thank you, Sam. Thank you.
If I can move on to ground 2A, which I hope will be swifter, my lords.
So sorry, just when you thought you were going to be able to move on, I was just looking on in the document prepared by your client on the 1st of July to paragraph 16.
Yes.
My position is that this family's privacy and P's privacy have been properly protected by the transparency order. We've looked this morning at the fact that the remit of the transparency order is pretty limited.
Yes.
This application doesn't seek to disturb that order. Their privacy could alternatively have been protected by a decision to hold the case in private. But that plainly wasn't your client's aspiration.
No.
Would the court have been wrong to hold it in private?
Well, that's something absolutely on the list of options that the court can consider at any given time. It wasn't an application that was ever made, to my understanding, by any party, including the appellant.
And then the final sentence is denial to court reporters of access to documents relied on in court doesn't afford the appropriate protection of the family. That's a reference to Professor Kitzinger and those who work with her within the Open Justice Forum. Reference to court reporters there. That's a reference to her, I think.
If I can turn my back to double check.
Yes.
Yes. Yes, it is.
Reference to herself. Thank you. Thank you very much.
Thank you. If I could turn back then, my lords, to ground 2A, that the proceedings became public proceedings, and I do hope I can take this ground more swiftly. It's set out in our brief statement at paragraph 5 to 6. So that's in the core bundle at 77 to 78. It's then in the skeleton argument at paragraphs 27 to 29, at core bundle 135, and my lords have been directed to the legal framework set out by my Lord Justice Peter Jackson in the Hinduja litigation, so I'm not going to trespass on that agreed legal framework now, but to emphasise the clear point is that post-2017, hearings in the Court of Protection are ordinarily in public subject to a transparency order. So that is the default position that is operative on the ground. And those types of orders are made ordinarily on an administrative basis by the court. And that's done at the outset of the proceedings. And if there's good reason then for a hearing not to be in public, that's usually dealt with as a preliminary issue at the first attended hearing. So the procedure that was operative at the date of the decision in July 2025 is accurately dealt with by the judge in paragraph 9.
When you say the procedure,
Yes,
would it not be more accurate to say the practice?
the practice.
Because I think the official solicitor says there is a procedure for this, which nobody seems to be applying in relation to transmission orders or whatever they're called. I mean, that when you say it's a procedure, this is apparently what people are doing. Is that what it means?
Well, that's what practice direction 4C transparency says, that ordinarily the procedure...
No, I'm talking about it all being dealt with on an administrative basis by the court.
Yes, so the order
By
is...
which I think you mean that people ring in and links are sent out and so forth. Is that what you were...
No, I'm referencing the time at which the initial transparency order is made. So the application goes into the Court of Protection, and the judge, when looking at the application and making initial case management directions, will make a
This is to do with the making
order.
of a transparency
Yes.
order. I'm sorry, I misunderstood what topic we were on. So
Yes.
now I understand.
So this is in relation to ground 2A, in relation to whether there's a public or private hearing. And my submissions, my lord, is that how Mr Justice Poole in paragraph 9 at A54 is dealing with the procedure that is happening, or the practice that is happening, it's accurate. So when he says the proceedings are in public, that is correct. A transparency order has been made, which makes the proceedings, or the hearing, because the hearings are then, obviously the order is made until further order. So you don't change the transparency order and reflect on whether the hearing should change from public to private at every given hearing. It would be for the person to say there has been a circumstance whereby we need to go into private, additional information that's come to light, that often happens, and there will be a change of stance. But when the order is made at the very outset of the proceedings, it's ordinarily that the proceedings are in public, subject to a transparency order. So the distinction that my learned friend is trying to make about proceedings being in public, being a special type of private hearing, it's a distinction without an end. It doesn't go anywhere. The process is as set out in practice direction 4C. And until such time as somebody says to the court, I have a good reason as to why this should be in private, then the proceedings are public. There's no hybrid of a special type of private quasi-hearing.
We looked this morning at the first transparency order made by Mrs Justice Tice,
Yes.
which I think is at page 42 and 43 of the core bundle. There she refers to hearings being public.
Yes.
Does she at any point refer to the proceedings being in public?
No. So it goes from one hearing to another, and then you ordinarily have the duration of the injunction in paragraph 8 until further order. So that's what we say in paragraph, or I'm so sorry, page 44.
Yeah.
So the hearings are in public as a result of an order that's been made under Rule 4.3. And then the court can restrict or prohibit the publication of information about the hearing. And we know that the first set of restrictions in paragraph 6 are limited.
Yes.
And then they're incrementally increased
As
on the
the
specific facts of the
proceedings
case.
grow.
Quite.
Yes.
But there's no distinction, as I think was raised, about it. The hearings that take place are in public, and that is what is stated by the learned judge. There's no error in law insofar as how he sets out the default position. He does say, in answer to my Lord Justice Cobb's position, the default position is for Court of Protection hearings to be in private. Then, I'm sorry, the submissions were, the default position is that the hearings are in private, then these are private proceedings. That is not how the Court of Protection rules and practice directions should be read. And it goes on to provide some further information that you can't have essentially private. They are public. The hearings are in public. Any member of the public may
That's not what he
observe the
says. He
hearing.
says the proceedings are in public.
Yes. And that's the distinction which I think Mr. Rutkin was laying emphasis to this morning.
Well, the transparency order certainly relates to hearings, and that is how the transparency order is developed.
Yeah.
But actually, as I put to Mr. Rutkin this morning, this doesn't make any difference to the issues we're really concerned with.
No.
Because whether it's public or private, Rule 5.9 applies. And the transparency order doesn't deal with the documents with which this appeal is concerned anyway.
No, my lord.
So there are two reasons why actually that's all rather, for me at any rate, tilting at windmills. Only for me.
No,
doubtless it's of
understood.
huge interest to everybody else, but for me, on the issues on the appeal, it's not top of my pops.
Perhaps ground 2B, the unlawful application of moss might be more.
Well, in fairness, Ms. Hutton, you didn't raise the issue, so
No.
you're simply responding to a rather broad and theoretical point that was brought into the discussion, which it's quite right that we should consider, but
Yes.
we've rather considered it.
Yes, and I do go back to what my lord said in Hinduja, that paragraph about the odd nature in how you get to the default position, that remains the position of Professor Kitzinger. I don't think I need to say any more.
Yes, right. Ground 2B.
2B, unlawful application of moss. So in the brief statement we provided, that's dealt with at paragraph 7 at page 78. It's also dealt with in the skeleton argument at paragraphs 30 to 32 at page 135. And if I can develop those arguments now, my lords, the point in terms of the judge being entitled to consider the decision of my Lord Justice Coulson in Moss, well, clearly he can consider it. The Court of Protection rules are not exhaustive of the various situations that apply when applications are made, and all parties here accept that there's no clear or uniform structure in the Court of Protection for the provision of position statements. So it was instructive, we say, to look to other jurisdictions for assistance. So that much is correct in terms of an ability to look at other jurisdictions. And my Lord Justice Coulson, at paragraph 34 in the decision of Moss, it's in the authorities bundle at 1374, makes 3 general observations about good practice regarding skeleton arguments and written submissions, appreciating what my Lord said earlier this morning about the overlap with committees looking at this more thoroughly. But looking at the 3 observations of my Lord Justice Coulson at paragraph 34, alongside Rule 5.92, it appears that the first point is problematic with the Court of Protection, as whilst it's very sensible for a non-party to speak to parties to ascertain their position, Rule 5.92 does not provide for the non-party and the party to agree matters between themselves. So that's the distinction between the operation of the 3 points in Moss in comparison to the factual matrix that we're dealing with in this appeal. Because what my Lord Justice Coulson goes on to observe at points B and C could apply in the Court of Protection. So applications being made as to the disclosure and the party objecting having an opportunity to say why. But it's the first observation that there is a tension in terms of how the judge dealt with the matter in this case.
I'm just asking myself why in a Court of Protection case, why a party to the proceedings should be the first port of call for an observer who wants to understand what's going on in the proceedings.
No, I'm saying it's not.
Right, well, it's. I mean, the way in which matters were framed in this case was to do with people asking for documents from people who are prepared to provide them. But I mean, my question is this: why should individual parties in the proceedings be troubled by requests from, frankly, members of the public, however well informed, for their documents? I mean, to take for an example, as you're well aware, there's a process in this court which is sometimes followed, where people bring their skeleton arguments and place them on the bench in front here, so that the members of the press who might attend can see the skeleton argument. That's a process that goes through the court.
Yes.
And I'm just thinking, why, if you were a family member or a doctor instructing a trust, or a social worker instructing a care authority, why would you want to have to deal with people, frankly, off the street, because they might be, with no pedigree, as we have in this case? I mean, surely if this is going to work in the end, it's got to be a process that works through the court, which I can see gives rise to all manner of problems, because in this case, for example, when I last counted, there were 17 requests for skeleton arguments in this court, which mischievously or otherwise I directed back in your direction.
You did.
Because there was no other, there was nobody else that I knew that had the, as it were, capsule of information, and was obviously willing to share it. But that can't work in the everyday case, because there aren't people like your client in a position to and I thank Professor Kitzinger, her team, for doing this, to do it in the average case. So this is not in any way in disagreement with my lord, because dealing with this in an entirely different context of the UT.
Yes.
But in this context, it seems to me to be problematic that, in a sense, parties, even if they've got lawyers, should have taps on their virtual doors and being asked for information. I'm not really sure why it's for the parties to uphold to be the first port of call for upholding the open justice principle insofar as it applies in individual cases.
And my lord, you've seen the witness statement of the official solicitor, where there was canvassing of thoughts from those at the bar in relation to how this works on the ground.
Yes.
And there can often be cases, and we've all been privy to it, when you're about to start a very serious case and I'll be bombarded with emails asking to do things, and I've got clinicians waiting to give evidence. So it does impact on how things are functioning. So certainly there needs to be a change. And I think the difficulty is, in particular, it's paragraph 36.5, and this is where the guidance goes astray. When a hearing is in public, subject to a transparency order, a party is free, it's that part, a party is free to provide a position statement to an observer attending a hearing without requiring a direction. And you can see that his lordship was trying his best, because there's a caveat to the end of 36.5. So there's trying to be an explanation as to why this is being done, but it falls foul of the procedural rule. So we say that that is something that can't be upheld. It's not contained within the rules as an exception, irrespective of those caveats being provided in 36.5. And my learned friend this morning referred to the nuclear rule of Rule 3.3 in the Court of Protection, which says you can dispense with any rule. So Rule 3.3, in dispensation with the requirements of any rule, would include Rule 5.92, but the judge could have done that had he thought it appropriate, but didn't.
So to be clear, because I haven't studied the position statement sequentially in order to understand what the judge had at every particular stage of the proceedings, 36.5 in the judgment was not a submission that was being made to him.
No.
By anybody.
That's right.
Your client included. She upholding the idea of proper openness. So that in a sense was more than she had asked for.
Absolutely. Yes.
Well,
I think
that's
it's fair,
great.
I think it's fair to say, my lord, that when everybody had sight of this,
Yeah.
it was a surprise, because specifically Rule 5.92 had been submitted by all the relevant professionals in their documentation. But I think what my lords have to grapple with in my respectful submission is how you deal with paragraph 36.5 in a 46 paragraph judgment that deals with the totality of the issues, because what the judge is saying is it might be helpful to set out a procedure, and that is what is said in paragraph 36. I believe the procedure that ought to be adopted is as follows, and then it goes on to provide sequentially points 1 to 10 effectively in paragraph 36. But what to do with that, because it's guidance, it's not part of the ratio of his decision. That comes later when he's dealing at paragraphs 37 onwards. So if the guidance being provided is not essential to the outcome, because he does determine the application.
Well, obviously, in relation to the individual decision, you'll have to deal with the extent to which his understanding of the principles influenced his decision making in the case. But I think everybody's agreed that although it's quote just guidance coming from the source that it comes from, it's clearly been acted upon.
Yes.
To a very great extent, and one wouldn't expect anything else.
Yes. Yes.
Yes.
But I think the point made in relation to this particular ground is that the judge, yes, went astray in relation to that particular paragraph, but did he determine the application for disclosure in accordance with Rule 5.92? And we say he did, so that the application that was made, the application before him from Professor Kitzinger is, I need a direction because I am not being given the documentation. The rights and wrongs of that are another point, but that was the application before the court, and he did determine it, and that's where we see the order being made for disclosure of the outstanding documentation. Ground 2C, my lords, moving on, this is the failure to apply the rule, which we've already touched upon. I'm not sure if my lords are going to be assisted by whether a document that's a position statement, a skeleton argument or written submissions are or are not court records, because that is something that's new in terms of being raised now. But can I make very short shrift of this? I've got 4 points in response to this, if it assists, because we say it does fall within 5.92. Looking at the reasoning of the judge, it's paragraph 6 and it's page 63 of the judgment. He's dealing with documents used by the court at paragraph 6, and he says, I am also satisfied that once they have been sent to the court, whether to listing or to the judge's clerk, they are documents within the court records within the terms of Court of Protection Rule 5.92. So the judge is specifically dealing with that head on. He has considered whether they are or not and come to that conclusion.
Sorry, which paragraph?
Paragraph 6?
Paragraph
Is that
6.
not the right paragraph?
No, I'm sure you have, but I'm
It's the very end of 26.
26.
Oh, I've lost the 2. I'm so sorry.
Yep, very end of paragraph 26
Thank you,
on
my lord.
page 63.
Yes, the very end sentence. Thank you so much. So that's where he says, I'm satisfied that the filing...
Yes, I see.
Thank you, my lord.
Well, I think you're. I know you're going to make a number of points, but I think you're on solid ground to say that for our purposes, we can work with the idea that these are part of the court record, because I think anybody who says they're not part of the court record is probably going to have to describe what they are.
Very well.
I mean, if they're not part of the court record,
What are they?
what are they?
Right. Just 2 very quick points then. I would like to emphasise the specific nature of the proceedings in the Court of Protection where we don't have pleadings. So judges sitting in the Court of Protection are enormously assisted by position statements. They are not the type of position statement that one sees in the family jurisdiction, and I don't say any discourtesy, but there are a couple of pages in terms of this is the position of the client. The documentation in the Court of Protection will set out the whole legal framework, what the issues are of the parties and why. So without plead-ins, they do take on a slightly different status within the Court of Protection. And the only other point to respond to, you were raised this morning in terms of what would happen if they don't fall within 5.9, and the discussion was whether that would fall within the inherent jurisdiction. How is that problematic? Because you've got Tier 1 and Tier 2 judges dealing with it. Can I just deal with the quotation for my lords to look at? It's what Baroness Hale said in the Dring case at paragraph 41. It's within the authorities bundle at 1210, and it's the different emphasis that's being placed on inherent jurisdiction. It's not inherent jurisdiction in the way that we understand inherent jurisdiction of the High Court. What Baroness Hale says is that all courts and tribunals have an inherent jurisdiction to determine what that principle requires, the principle of open justice, in terms of access to documents or other information placed before the court or tribunal.
So calling it the inherent jurisdiction is really, it's in a sense, the short point is the courts have got powers to regulate their own procedure. Absolutely.
It's not inherent jurisdiction in High Court sense. So the Court of Protection, if it doesn't fall within Rule 5.9, has an inherent jurisdiction at whatever tier of judge to determine the constitutional principle of open justice in terms of access to documents. And my lord, the official solicitor has put forward a test if Rule 5.9 doesn't apply. All I intend to say about that is that Professor Kitzinger does not agree that there needs to be strong grounds for thinking that an order for access is necessary in the interests of justice if it falls within the inherent jurisdiction. We say that type of formula being put forward in this type of case doesn't assist. But as to the substantive point, so whether the judge failed to apply Rule 5.9, as I indicated in the earlier submission, he did apply it. That was the specific application before him. And just to be clear that he understood that that was the specific application, it's paragraph 5 of the judgment at page 52, where he says, Professor Kitzinger seeks a direction accordingly for the provision of all position statements from all those hearings as well as the current hearing. And he refers, my lords, to the applicable rule at paragraph 26. If I could move to ground 2D, which is the failure to apply Rule 5.94. So this is all about redaction. Following the application of Professor Kitzinger, my lords have the 15-page document that was provided in response by the appellant, dated the 2nd of July, at page 264 of the supplemental bundle. Having gone through those pages, I can't see that there are any aspects of the position outlined by the appellant where she says, these are the documents that I've provided, this is what should be redacted and why. And in my submission, there is a duty on the parties, my lords, in the exercise of the overriding objective to ensure that if there is an issue that they seek to raise with the judge, in this case, redaction of certain sensitive information, that it's incumbent on them to do so. And there's no reference in the documentation. So the point I make is that it's wrong for the appellant to now submit that the judge should have considered an argument that was not put before him. So specific redactions are commonly requested, and there's particularisation of what on behalf of your client you are saying needs to be redacted. And there's no such information that I can see. Would you accept
that my lord's timing point is going to be relevant to that submission? I mean, I understand that submission, but if you've got 24 hours or whatever it was to respond, you may not have particular paragraphs and redactions in mind.
I accept that.
That's a very micro level type point, and given all the other things that were going on, I mean, I completely understand that submission, and I completely understand the point, well, that particular redactions weren't before the judge, but that might be said to be part and parcel of the process that the judge adopted and the timing.
What I would say in response to that, and I do accept the point in principle, is that the judgment came back on the 15th of July. Rule 1.5 of the Court of Protection Rules specifies that the legal representatives are required to help the court to further the overriding objective. So as of the 15th of July, when the draft judgment is circulated, if there's a material omission, then again, the expectation would be that it's now raised. The basic point is if there were obvious redactions that were requested, it would have been incumbent to raise, not to criticise after the event. But in any event, the judge was aware that the position statements weren't fully anonymised.
Yes, clearly there are elements of practicality, namely that there's a point at which the parties are applying their minds, the court is applying its mind to the issues that arise in the case. But obviously, the sort of things we're talking about on this appeal are as nothing compared to the main orders that the judge was making at the time. And so therefore I don't quite understand why there was any urgency at all about this disclosure issue. I understand that the judge might want to set a timetable while everybody was there and could participate in an orderly procedure. But it does seem to be particularly unfortunate that this was an issue which was not only being timetabled but also decided at a time like that. I make perfectly clear that it's not a point that's critical of any of the parties involved. But I mean, this was something that could have gone off to be decided months later without any loss of understanding of the process. It's not a news story.
I don't know how the timetable was set, having not been
No,
there.
I mean, you're here fielding responses from the court, submissions from other parties in respect to an order that you were not involved with. We quite understand that, but I don't see. I'm not sure that anybody sees that this needed to be done lickety-split. It was something that could easily have been dealt with some while later, when the focus was bound to have been elsewhere.
I'm not aware of there being any trigger event, something in the future that tied the timetable to what we have, my lord. But to go back to the specific ground of appeal, that it was the court's failure to apply Rule 5.94, I do think that yes, the obligation is ultimately on the court to consider the matter. That's clear from the rules. But the expectation is that a judge wouldn't look at this in a vacuum. If there are specific points to raise, the parties, we say, should be raising them, and that's not uncommon. And it's still unclear, looking at the documentation from the appellant, what specific issues are particularly sensitive. I've heard that there are issues of sensitivity, and I don't say that there's not, but the specific paragraphs and the editing aspect, that hasn't been articulated. So that's in relation to ground 2D. Ground 2E, this is the transparency order being sufficient protection against the Article 8 rights of the family, and the appellant submits that the judge was wrong in undertaking that analysis. And I think it goes back to the point, my lords, that has been discussed this morning about what is the purpose of the transparency order. The transparency order that we see, it's the 23rd of May, that's the most up-to-date one at page 160. It prevents, as we know, this extended information about who Mr. Gardner was, his family, and specific issues pertinent just to him. The judge is aware that the transparency order is going to expire on the 30th of August when he's making the decision. So this is not a matter that was material that he didn't consider. And the date was known to all the parties. So the judge assesses the facts as at the time, so the 15th of July 2025. He's not invited by any party to extend the transparency order at that time, and the aim of the transparency order is to protect Mr. Gardner rather than confer anonymity on other individuals. It may include family members, as it did in this case, and that's usually the jigsaw identification argument, but that's not always the case. So if the injunction is to protect the anonymity of Mr. Gardner's rights, how the judge looked at it is that the protection of the family was incidental because they are tagged on, as it were, to the provision setting out the anonymity for P. And we see that within Practice Direction 4 at Practice Direction 4A at paragraph 27, which makes it clear what the purpose of an order restricting the communication or publication of information is. And that's in the authorities bundle at 934.
Thank you.
So it's to avoid jigsaw identification of P as opposed to freestanding Article 8 rights of the family. And that's what is stated by the judge at paragraph 35. Any protection of the privacy of the family is incidental, but incidental or not, the appellant and other members of the family were protected by the terms of the transparency order. And it's set out at paragraph 37.3 that the transparency order allows the reporting and communication of certain information, but without undue influence of the Article 8 rights of P and others, and that is the balance struck. And we see that at page 67, my lords, of the judgment.
Something I've missed is how we got to the 30th of August as a terminal date for the transparency order. Because the original order was made until further order.
It was.
In May. And then there was the order of the 14th of July, which provided for any application to vary it to be made.
So the missing part of the puzzle is
Yes.
page 233.
Thank you.
And it's the order of the 30th of June. And
Supplementary bundle 233.
yes, paragraph 12, that's right, my lord. So what it says in paragraph 12 is that the transparency order dated the 23rd of May shall cease to have effect from the 30th of August. So it's contained within that judgment as opposed to an amendment to the transparency order. And that was the judgment where, as we know, all the parties were legally represented. And my understanding is that that date was agreed between the parties at the hearing, that that was the appropriate date for the transparency order to cease to have effect. I'm told that the rationale for that is on the basis that if one looks earlier on in the order, we have the move to palliative care in paragraph 6, and it would go to the Abassi authority that it provides for date of death and a cooling off period thereafter. So that's where the date came from, but the discussions as to the specifics, I'm not sure.
Thank you.
And then just going back to how the judge undertook the balance, he explains at paragraph 42, my lords, at 68, that there are protections under the transparency order when he made the order, and that the Article 8 rights of the parties are protected. He also sets out at paragraph 43, which is at page 69, that Professor Kitzinger remains bound by the transparency order, which protects the Article 8 rights of Mr. Gardner and his family, and that the direction for the provision of position statements was proportionate.
But does the transparency order protect the Article 8 rights of the family when the position statements contain so much more detailed information about Mr. Gardner and his family than was covered by the transparency order.
There was no application to amend the terms of the transparency order by any party. So I'm not sure what I can say other than that which is set out at paragraph 43 from Mr. Justice Poole's analysis.
Well, that's a counterfactual, which is that the transparency order could very well have included no reference to these issues or no reference to that issues, and such orders sometimes do that. I think the point that is being made against you by Mr. Rutkeen on this is that, as a matter of fact, it didn't protect. It would be one thing for the judge to say, I've considered the Article 8 rights of the family members, for whom I have the utmost sympathy, but those rights do not extend to a continuation of transparency order protection by means of withholding of skeleton arguments and things like that. That would be one thing, but the judge appears to have thought that they were protected, whereas the point is being made that actually they weren't.
But when one looks at the terms of...
Do you see the distinction that I'm
No,
drawing? It's one thing to say that the rights don't prevail. It's another thing to say that the rights are not breached.
No, I do understand that point, my lord. But if one looks at the terms of the subject matter of the injunction, at page 162, so this is the transparency order that's operative at the time, it's not only containing the identification by name of those persons who are members of Mr. Gardner's family, and there are a list of those in paragraph 6, but paragraph 6.2 is any material or information that identifies or is likely to identify where they live.
Yes.
And also, when one looks at paragraph 6.1a, that he is the subject of the proceedings,
Yes,
and therefore
but the sensitive information here was to do with the intra-family dispute. That is not covered by the transparency order, even this version of it.
But in relation to paragraph 6.1a, that he is the subject of the proceedings and therefore appears defined in the Court of Protection, the content of the position statements is all predicated on Mr. Gardner being the subject of the proceedings.
Well, I'm afraid that's not what... I mean, if somebody was hauled up for referring to the unfortunate disagreement within the family on the basis that they were in contempt of the transparency order, then that application wouldn't get very far. There are certain things that are clearly prohibited, but the fact that there was this unfortunate family issue is not one of them.
I understand the point that's being made. The position of Professor Kitzinger is that the transparency order was sufficient protection at the date of the decision in July, and any extension...
Well, I understand that. That's a different point. If your submission is that actually you couldn't refer to the fact that there had been a sad disagreement about the circumstances of the advance directive and who had behaved in which way and who had behaved in that way and so on and so forth, I mean, you should make the submission. But if you don't feel you can make the submission, then that's...
No, I can't, and I have referred to the specific paragraphs of the judgment where the judge says that he undertook that analysis. I don't think I can take it any further. I can say that the decision could have been more detailed, yes. Did he have to rehearse all of the arguments? Reading the judgment as a whole, the position of Professor Kitzinger is that it's clear how the judge made the decision that he did. And my lords then have the detailed judgment of September, when there's the Article 8, Article 10 analysis that led to the transparency order not being extended. But I don't think I can take the point any further.
It's a matter of interest. Are there any rules in the Court of Protection about the filing of position statements and skeleton arguments?
Not that I could find. It's certainly a direction that's made.
No, I mean, I don't remember that there are any, because I think the practice generally is that represented parties and indeed unrepresented parties try to help the court by providing them with up-to-date statements of their position and summaries of their argument.
Yes.
But unless the court was to have, assuming there are no rules that say it, and between us, we ought to be able to identify.
That there's no specific
them
conduct
if
protection
there
rule or
were.
practice direction.
And secondly, that the court has not ordered position statements, which it never does because it expects them. Does it not?
No, it does order.
It
It'll
orders
order.
provision.
It orders.
What are we talking about? 48 hours before or something of that sort? Is that?
It's
what
normally
was
the.
happening in this case?
I'm not sure what happened in this case, but ordinarily it's the applicant to file, the respondents to file, and the official solicitor will come in last, a few days in advance of the hearing. So it's sequential filing of position statement. And in my experience, it's at every case management hearing there will have been a direction.
Right. So.
And there are, sorry.
I beg your pardon.
No, go on.
But so you would expect, if we were to go through the directions that happened in this or any similar case, there would be directions in relation to the dates of the filing of particular documents.
Supplementary bundle 159.
Supplementary bundle 159. I'm told that there's
Thank
an
you.
example of that happening.
Paragraph 14.
Paragraph 14.
So those are the directions that were made, but it's your understanding that there are rules which provide for that.
Not specific rules, it's the general case management of the court.
Oh, it's
and
a
the
general
rules
case
will-
management.
Absolutely.
power.
So in advance of the next hearing, the judge will determine what issues need to be looked at, but it's the case
Yes.
is listed and then the case management directions are after the listing, and it's always, in my experience, and I'm sure the others on this bench, that there will be provision of documentation. And some judges are more specific in terms of what's expected, and they'll set out the issues that would be helpful to be incorporated. But certainly that baseline direction that we see in paragraph 14, that's bread and butter of a case management order that you would see, my lord.
And the order is specific that it's filed.
Yes. Yes, shall file and serve. Yes. I'm just thinking if there's any circumstance where it wouldn't be shall file and serve, and the only example I can think of is if there's a litigant in person who, by reason of having provided a witness statement, there wouldn't be a need to duplicate. So moving on, finally, the final set of submissions in terms of guidance for future cases, which I think is more straightforward in relation to how I'm able to assist the court. The procedural issues are firstly set out, my lords, at paragraph 40, which is at 138. So if we could turn that up, it's the first skeleton argument that's been provided, and just to see where we land in terms of the discussions that have been had so far. So it's 138. The paragraph is changed to paragraph 43. Does my lord have
I'm
that?
sorry, which I mean, I thought I have 138 in front of me, and there's a paragraph with a beginning in 39 and initial thoughts. Is that the paragraph
Yes.
you're taking?
Yes, that is the paragraph.
Yes.
And the initial thoughts, taking what my learned friend said about the Rules Committee and the necessity within the ambit of this appeal to provide clarity perhaps on the ground, at least for the interim, and what could be done sensibly to assist. I don't think the comments that have been made in that document are controversial and are meant to be helpful. So insofar as paragraph 1 is concerned, my lord has the point in terms of how the court applies it, and the specificity to say that it is an other document for the purpose of the court is going to be helpful, so judges immediately know they have to apply under a rule as opposed to exercise some sort of discretion. It is incumbent in my respectful submission for this issue of anonymisation to be dealt with. But I do take the point raised by my learned friend this morning that it's not at every hearing it happens, and it is time consuming having undertaken the task. So what may be appropriate is to provide your documentation in the way that you would in any case. And I agree with my Lord Justice Coulson entirely that there should be no watering down of documentation for the point that somebody may or may not turn up at the court. This is akin to a pleading where you want to put your best evidence on behalf of your client. You shouldn't be shying away of incorporating important information because somebody may or may not turn up and indicate an interest. But the provision of anonymising everything on a just-in-case basis is likely to be disproportionate. So there would need to be some way of being able to deal with the anonymisation not immediately because you're dealing with the matters of the case, but during the process of a hearing, it shouldn't be too difficult. The anonymisation point is straightforward in terms of changing the names of professionals to whatever the anonymisation would be and the family members. And what has helped in some cases, if there's particular sensitive information, the easiest way is to put it as an appendix to the position statement. If you do it in that way, you are able to give the court all of the key information and then extract the particularly sensitive part before there's onward disclosure to any members of the public. So that's one thought in terms of how to ease up the burden.
But it's also that if in the best practice that these things are thought about at the earliest possible stage, then, for example, the position statement that goes to the court at the early stages might say, it seems to us that these are the sensitive issues that might
Yes.
need to be thought about when considering any redaction or withholding.
Absolutely, because the way in which it's dealt with at the moment is chaotic, is the word. There are lots of things, as my lord will know from practice, happening at the start of a trial, and this is something that is an unnecessary distraction and in some cases takes away the focus from the matters at hand. And that's not because anyone is not trying their very best, but it is something that needs to be looked at.
We also well understand the frustrations of somebody like your client who's trying to understand these matters and to use her time to best effect and not to have to fight the system.
It's very much ad hoc at the moment, so if there's a streamlined way of universal application until such time as the Royal Committee looks at it, all well and good. But
so whether it's chaotic or more politely organic, the way things happen at the moment, it still means that an observer or indeed a legal blogger or a reporter does not know exactly what they're going to find in any particular court.
no, and there's a wide disparity in terms of how different judges approach the matter. But insofar as the anonymisation, the sensitivity aspect being dealt with perhaps in appendix, all of those matters are sensible, practical issues that I think my lords will be able to determine without trespassing on any wider issue and consultation process. There's the issue that my lord at first instance dealt with in terms of a warning on the sheet, the first page of the position statement, in terms of the fact that there is a transparency order, so to be reflective of that also. There needs to be an application to court. I think everybody is in agreement for that. But the one point I would raise, my lords, and ask you to consider, because it is important for Professor Kitzinger, the official solicitor is requesting that there's formality of an application being made on every occasion, and that simply is not capable of practical implementation in the real world, because an application would suggest that Professor Kitzinger is aware of the ins and outs of the particular issue. The listing will simply have welfare sometimes without any clarity as to what the hearing is about. So there needs to be a degree of flexibility of an oral application being made in the first instance. And of course, if something happens after the event, although that would be avoidable if possible, then the formality would kick in, as it were. But the suggestion that this is all done the morning of a hearing, because the listing only goes up very soon before the requests are made, it just won't work. So
at the moment, the rules provide for Part 10, and there being as you put it, a formal application. That's what the rules say.
They do.
And certainly reading the rules, the oral application would appear to be an exception and not the rule.
Take that into account.
It's a bit difficult to go beyond that.
But one has to think what the application would include. There would be no detail of the basis of the application that is being made, because at that stage it's simply that there's a public hearing dealing with welfare issues, but no understanding of what is actually before the court. So there needs to be given some thought about the benefit of that application being made for both the person making it and the judge determining it.
Sounds like a matter for the Rule Committee.
I think my lord is right. trying to deal with things
But
at
I'm
sort
not
of
trying
high
to,
level.
speaking personally, I'm not trying to duck it, but it is always difficult to be asked to give guidance in circumstances where there aren't rules. Obviously in Moss we gave some guidance, but we were very anxious to stress that it was really the province of the Rules Committee, and there are, to that extent, similarities between this case and Moss.
All that could be said, therefore, would be that the expectation is that a Part 10 application is made, so that means an interim application, but the court can exercise their discretion and dispense with that if they think fit on the particular facts. But it does create huge practical issues for those seeking to have such information provided.
But it also creates huge practical issues if it's raised when everybody else is focusing on what might be said to be the substance of the hearings. That's the difficulty.
I agree. If there's agreement once an application is made, then that can be dealt with properly, and that has happened where there's no disagreement and the judge can make the order at the very outset of the hearing without any trouble. If there's disagreement, there's suggestions within our document, my lords, in terms of how the court would proportionately deal with that, but ultimately it's a matter of discretion for the individual judge who knows how much time they have to deal with matters prior to dealing with the substantive issues. I accept entirely it shouldn't detract from the main issues in a case. And as happened here, paragraph 8 of our document sets out that if needed, the court will have to hear submissions and ultimately have a short ruling in terms of how the application should be determined, ideally in extempore on the day type short ruling.
It could also be looking at your paragraph 8. The court could, as it seems to me, perfectly well take the view that it's not going to determine the application simply because, maybe through nobody's fault or because of the listing arrangements, the thing arrives at 9:50. The court already has its head in the facts of the case. It's not prepared to spend any of the time that has been reserved for the individual case on this particular discussion. I mean, rather in the same way that nobody would expect that if somebody arrives in an actual room and comes in at the back at 29 minutes past 10, and then as the court stands up and says, "Could I please raise a question about a position statement?" I think I ought to have some position statements. I mean, nobody would expect a judge who had a busy list to do anything other than say, well, perhaps you better take it up a bit earlier next time. I'm not going to spend any time thinking about this, that we cannot have an expectation that everybody's simply going to drop everything in order to deal with these requests. Although I'm quite well aware that some people who want to attend hearings get very limited notice of them. So there's a rock and a hard place in this. But in the end, probably where there are rocks, a hard place, one of them has got to prevail, and it's almost always likely, if they can't both be done in the time, to be P who gets the time and not the observer.
And that deals with the areas of grey that I indicated earlier, that it's not all or nothing, disclose a position statement or not. As part of the opening of the case,
Yes.
I would go through the issues in detail.
And as my daughter said, it's another aspect of the timing point.
Quite. And Open Justice would be engaged because there would be knowledge of the issues by way of the oral submissions that I make as to the issues in the case and what the court needs to decide. So it can be dealt with in that way if there's little time. I completely agree. And the editing and the redacting point, my lords, that's set out at paragraph 11, simply to say, for a judge dealing with these matters, they are making the decision as to whether an application for disclosure to a non-party is being made. The suggestion that they would then, within a limited amount of judicial time prior to starting a hearing, have to then go through an editing redaction process at the same time. There has to be some give from the party to come with their suggestions in terms of any redaction. It's just not possible, in my respectful submission, that a judge would be able to do all of this at the start of a hearing and then deal with complex matters in relation to the welfare of an incapacitated person. So I've just raised the specific rules that there are specific duties of the parties to assist the court when making determinations and to help ease the way, as it were, when dealing with the requirement for redaction. And I entirely agree with what Mr Justice Poole said at first instance, that if this all happens after the event and there's time to do so and the person hasn't been at the hearing, then the formality is required, and perhaps there would need to be greater detail as to why the principle of open justice applies in that type of case. But certainly I would suggest that there is an interim mechanism that my lords can put in place. It certainly doesn't have to be at high level, and what my lords are effectively doing is rectifying the mischief of 36.5 within the judgment of Mr Justice Poole, but taking on board a lot of the other very helpful guidance points that he does set out. It's not the type of guidance that simply is discarded because of one rogue paragraph that has the pull-in between what is set out there and Rule 5.9. There are lots of helpful information set out there that could still be utilised once the Rules Committee are looking at the matter. Insofar as Section 85 and transmission directions, please may I leave that to my learned friend, Miss Scott. She has specific points to raise on it. I understand the points that are being made and the principles that sit behind it, but I don't want to trespass on her.
Well, it rather depends upon whether you're agreeing with her.
Yes, I can. Yes.
And so is it the fact that there is a process, which is a fairly heavyweight process that exists for dealing with these matters?
No, it doesn't go so far. It's not as bad as that which is set out by Miss Scott at paragraph 25.209. The court does know who has made a request because there will be an email address sent to the court. So if it's an issue of online attendance and observation, then the court will know, and the court will ensure that the terms of the transparency order are emailed to that person. So there is some protection in relation to what is covered by the terms of the injunction. And in addition to sending it, then the judge ordinarily will say at the outset of a hearing, whoever is present in terms of members of the public, have you had the transparency order? Can you confirm you know the terms of it? So that is something that happens, but other than that, there is limited input.
Yes.
My lord, it's now 3:30. I've used my 1.5 hours.
Well, there's just one thing, which is can we get down to cases and consider what's to happen to these documents
Yes.
if the appeal were to be allowed? What happens next?
If the appeal is allowed, Professor Kitzinger has absolutely no issue with ensuring that any copy that she has will be destroyed. She doesn't have any documentation saved on her system, but she does now have the documents that we all have before us. So she has again the position statements that she'd previously deleted. So she'll ensure that they're destroyed.
So, I mean, that's obviously extremely helpful, because what it seems to entail is that if we were to decide that the appeal is to be allowed, we then don't have to go on to make any consequential mandatory order in relation to the documents which were disclosed under the judge's order, on the basis that they've been treated with forbearance up until now, and they would then be deleted voluntarily.
Certainly, my lord, and I emphasise at this stage that at no point during the course of these proceedings has Professor Kitzinger sought to upset any person involved in the case. And in terms of how she's going to conduct herself with any deletion of documentation, that will absolutely be done. There is no issue there at all, my lord.
Because you will have heard the exchange with Mr. Hakim, because otherwise I would think what we would have to do is not just say, well, we don't disagree with the judge, therefore you can't have the documents. We'd have to ourselves consider whether you should have the documents, applying what we thought to be the correct approach.
Yes.
But it looks as if in that event we're spared having to go through that process because it's not an issue that's live between the parties. And this can be treated at a level of principle rather than these particular documents once we've got to this point.
There is the issue about Mr. Moss, and I don't know what to do with him because I don't know who he is.
You don't represent him.
But that is a loose issue in terms of needing to be tied up as to what documents he has, if any. So I just leave that there, that is a matter to be tidied up.
Right, well, we won't lose sight of that. Is there anything else?
No, my lords, those are the submissions on behalf of Professor Kitzinger.
No, well, could I just particularly say to you and to Miss McNeill-Walsh, that the Court's extremely grateful to you, and I'm sure Professor Kitzinger is as well, for you being prepared to act pro bono on this appeal. It's meant that we've been able to get a much wider view of the issues than we would otherwise have been able to do.
Thank you, my lord.
Yes, Miss Scott.
My lords, the focus of my submissions are going to be on the guidance that the court's being invited to give, and the emphasis the official solicitor has on any procedure or any guidelines is to ensure that the parties, and crucially the litigation friend, is given sufficient time to respond to any application brought by an observer for a position statement, so that they can carry out all the tasks that they need to be able to protect P's Article 8 rights. My lords will have seen the evidence filed by the official solicitor, both from her caseworkers and from the COPPA, Court of Protection Practitioners Association's survey, which sets out some of the very significant impacts that the presence of observers, in particular at hearings, whether remote or in person, can have on Ps. And while I'm on that point, there is a plastic file on each, my lords, of your benches, which has the COPPA survey in slightly larger type.
Thank you.
It's exactly the same as the survey in the papers, but I hope at least you can read that. In common with the other parties, the official solicitor is only inviting the court, for reasons that have already been explored, to set out guidance at a matter of general principle, and for the matter then to be to go off for detailed consideration to the ad hoc rules committee. I'm going to start my submissions at looking at the practice in other courts, and in my submission, the practice that should be taking place in the Court of Protection for remote attendance. The practice at the moment in the Court of Protection is informal. As we've heard, it involves those that wish to observe, members of the general public, emailing in to the court for a link. My lord, it is right that sometimes the court, and often the court, will provide those members of the general public with the transparency order and check they've received it and check they've understood it. But that is not invariably the case. And at the risk of giving evidence, I have had many hearings where I have had to email at the beginning of the hearing the transparency order to the members of the public on the link, and have had to try and ensure before the judge comes on the link that they have understood it.
Well, who are these requests being addressed to? It's to the official solicitor, is it?
My lord,
in the case that you're doing it, or are you doing it on behalf of the court?
I'm doing it on behalf of the court. So, my lord, what will happen is you dial into the link, and there will be a court clerk there, and there will be members of the public will start coming onto the link before the judge comes on, and hopefully before the recording has started, at which point I will always turn on my camera and my microphone and say, have the members of the public present received the transparency order? Sometimes the answer is yes, and sometimes the answer is no, at which point steps are taken to ensure that they do have the order. And sometimes the clerk won't have their email, etc. They have to.
It sounds as if you're acting as an unpaid judge's clerk,
Well,
in effect.
the difficulty is that when one is in front of a tier 3 judge who has their own clerk, there's a point of contact between advocates and the judge. If you were in front of a tier 2 or a tier 1 judge, that's not the case. So they don't necessarily have their own clerks, or if they do, it's not public knowledge who they are and how to get hold of them. And so one has to deal with those matters on an ad hoc basis as the hearing begins.
And again, so we can have the benefit of your experience, because it's changed since COVID so very much. You're talking about cases in Tier 1 which may, for example, be serious medical cases.
No. Tier 1 is district judges, Tier 2 effectively circuit judges, Tier 3 High Court judges. Usually serious medical treatment cases are in front of High Court judges,
They're
not invariable.
I'm sorry, when I said 1, I got
Yes,
the numbers
indeed.
the wrong way around.
Yes.
But if you're in front of a High Court judge or a deputy, then it might, for example, be a directions hearing that's taking place on screen, or will it almost always be in court?
It may be a directions hearing that takes place on screen. It's usually for a substantive final hearing it will be in court, but not always. And sometimes it will be a hybrid. Often it will be a hybrid hearing, because in serious medical treatment cases,
The doctors.
the court is reluctant to get the doctors to come away. So there will be observers on the link, counsel and
Right,
solicitors.
and do you have any impression of how many observers there might be in a high-profile medical case?
I mean, I've been in a high-profile case. I've been in cases where there have been members of the press, multiple members of the press, multiple members of the public. Sometimes I've been in cases where there might be 30 observers. That's unusual, very unusual, but it does happen. Usually
The numbers
you'll
are
have one or
such
two.
that if they're going to be dealt with on an individual basis, it's a considerable resource issue.
Yes. I'd stress that's very unusual to have that many in my experience. But
And there might be plenty of cases, maybe not so many, that senior advocates are involved in where there are no observers at all. In
absolutely.
fact, one might make the working assumption that the very great majority of the work of the court, maybe 99% of it, goes on without anybody being available to watch it in action.
Absolutely.
And that even the amount of observation that's taken place is a recent development.
Absolutely. So, the point I wish to emphasise is not necessarily the role that I play in trying to ensure that observers have seen the transparency order, but that very often the parties do not know whether this is going to be one of those hearings where there are going to be observers present. And the reason that that's important, my lord, is this. How does one prepare for these cases? Does one have a position statement that can easily be disseminated to observers if they are there at the cost to the public purse and or your client for every case? Or do you wait and see whether or not observer attends and then try and deal with it? And that's clearly unsatisfactory, and you've heard, my lords, that that's unsatisfactory, and the Copper survey shows the difficulties that arise. So the official solicitor is extremely keen to try and ensure that the procedure allows for a proper understanding from the parties as to whether there is going to be an observer there in time for them to carry out the investigations and do the
In your
work they
case,
need to.
you place particular emphasis on the fact that if anybody's going to have to take a view about the disclosure of documents and in this way, it really ought to be the person who's at the centre of the proceedings, the representatives of P. But most of the work of the official solicitor, I guess, is subcontracted to what used to be called agents. I don't know what they're called now, but local solicitors who are acting on the instruction of the official solicitor.
Yes.
And in relation to a matter of that sort, is the decision as to disclosure and so forth delegated to the solicitor, or does it have to go back to the official solicitor's
It goes
office?
back to the official solicitor.
Right. So that seems to me at the moment to be a circle that's very difficult to square, because if requests are coming in from all over the place in relation to observers, it's impossible to see how there's going to be enough time, as they're normally made at a very late stage,
Indeed.
for the official solicitor to be able to deal with those in an orderly way.
My lord, that's right, and also that doesn't even add into what needs to be done, the very important step of where it is possible and appropriate to float these ideas and put them, ask P what they think. What do they think about observers being present? What do they think about position statements being disseminated with information in? And now that's often not appropriate because P won't understand, but certainly had hearings where the presence of an observer at the last minute has caused very considerable concern and distress to P, and you, my lords, have evidence about that from the Water Protection Practitioners Association survey. So, my lord, what the official solicitor suggests is the way that the court should be dealing with applications for observers should be via the statutory scheme from in the transmission directions, so the court can make a transmission direction. I'm just going to spend a little bit of time, if I may, taking the court through that scheme so that you can see the detail of it. And so if we could start with the Act itself, please. That is at electronic page 488 of the bundle, which is in volume 2. And that's 85A of the Courts Act 2003. And we can see that the paragraph 1, this section applies to proceedings in any court.
So just checking, this came in April 2022.
Yes.
Okay. And can you shine any light on the timing of this? Is this to do with sentencing?
I don't know. I don't know why it was added in that particular by that particular act.
Anyhow, it's not. It's very definitely not a COP focused.
It certainly isn't.
I think without giving evidence, I think it's a post-COVID
Yes, it is.
tidy up of what effectively, in some respects, at any rate, was happening during COVID.
I think that's right, my lord, and we'll see that in one of the documents I'm going to take you to. It sets out in terms of the timing.
So partly it's like overflow courts that it can be covered by this, and also individuals who have first identified themselves.
Indeed, exactly. And my lord sees that proceedings need to be specified, paragraph 2, and we'll look at that in the regulations in a moment. And then the two different kinds of transmission directions set out at paragraph 3. We're concerned mainly with 3B, individuals who are given access. And then importantly, paragraph 5, which gives the court the power to make a transmission direction subject to conditions. And I should also emphasise paragraph 3B, what it says there, the transmission can be made to individuals who are given access only having first identified themselves to the court. So, my lords, that's the first document I want to take you to. Then if we could go, please, to the regulations, which is in volume 2 as well, and it's page 925 of the...
Right, so these directions are to do with observation.
Yes.
So we're not concerned here with documents.
Correct.
And I suppose there may be a case in which somebody would be fine for somebody to watch, but not fine for them to be given a document.
Indeed.
Not necessarily hand in hand.
And indeed, they don't sit hand in hand at all. The point that I wish to make is that this process, this procedure, gives the court an opportunity to make directions to say, and we'll see in a moment, the court has the power to make a direction to say an application for a transmission direction for this case needs to be made by X date, And that would also give the court an opportunity to say, and any application for a position statement should also be made by the same date. So the procedure for position statements can be slotted in to this procedure.
And this also, of course, perfectly obviously doesn't apply for people who are attending live hearings.
It does not. And the issue with, as Mr. Rutkeen made the point in his submissions, I think he called it feels particularly edgy or something of that sort when one is sending position statements into the ether. In my experience, when people come into court and want to see position statements, one can hand over a written document, and then once they've read it, you can ask for it back. And that's how I have done it in the past, which feels rather different from sending electronically position statements to people who you don't know who they are.
When you might be thinking about journalists, are you here?
Or members of the public. So if a member of the public comes in and they want to see the position statement, sometimes they will ask, if it's a law student or something of that kind, they will ask to see the position statement. And if there is a decision or an agreement in whatever form it is that is appropriate, they are often handed a copy of it. They read it and then
Does that run through the court?
No, I don't know is the answer to that. I have seen that done in court. So we see there in the regulations, paragraph 2, that these regulations apply to proceedings which are held in public. So once a transparency order is made, they would apply to court of protection proceedings. And then we see the threshold criteria in regulation 3, 2 threshold criteria: interests of justice to make the direction, and there is capacity and technological capability, and it doesn't create an unreasonable administrative burden. So if those matters are satisfied, the court can then go on to make a transmission direction. But before doing so, the court must look at what is said in regulation 4. I would invite the court to read that, placing particular emphasis in court of protection proceedings on D&E, which relate to the fact that there will be a transparency order in place. Anyone that is going to be attending remotely will need to understand that and have seen it. And the court will need to consider whether, if the person is outside the jurisdiction, they can be said to be properly bound by it.
I thought B is also one that you're
Indeed.
focusing on.
Indeed.
At any rate, all of this is in a sense analogous rather than directly applicable.
Indeed.
So I was not right to refer to it as covering this. It covers the request for the link,
Yes.
but it doesn't cover the request for the underlying
The
document.
position statement. No.
But I thought I'd understood you to be saying that if we're looking at the way forward, one could use this template,
Yes.
as I think your phrase was, to slot in
Yes.
the requirements
Yes.
that we're talking about.
Because it all starts with, well, it usually starts with a member of the public requesting a link from the court. That's the first anyone knows about the fact there might be a member of the public appearing. And so if this process is followed, there's an opportunity to set up a procedure that gives notice to the parties so that they can then do what they need to do, so that the court can then make a decision about whether or not a position statement should be granted, hopefully in advance of the hearing. And if so, on what terms?
But even so, we start with the observer who is wanting to make a request. The next port of call is the court. The next port of call is the court to the parties.
Yes.
The next is the parties to the court.
Yes.
Then it's the court that makes a decision.
Yes.
And then at that point, there's then an issue as to how the decision is to be carried out,
Yes.
in which may not be at all easy, bearing in mind, in the light of whatever the court's decided, whether there should be or should not be restrictions on what is to be disclosed, and the issue then arises as to who to who is actually to carry it out. Is it to be the court telling the parties to do it, or the court telling the parties to give it something so that it can then do it? I can see that there's a series of steps, but the general acceptance in this appeal is that by seeking to say it's just up to the parties, and anybody can ask a party, and one doesn't go through any of those
Yes,
processes, is not what the law says at the moment.
indeed. And my lords, I would ask you, I won't take you to it now, but also to consider paragraph 5, which is the provision which makes it clear that the parties must identify themselves to the court, so that the court is aware who they are, and the court can a direction must include a prohibition on anyone that is not entitled to be present to be on the link. So the court retains some control over who is on the remote link.
So 5.1b.
Yes, so 5.1b, my lord, I think that relates probably to those proceedings that are not in public, but for which a category of people are able to attend. So, for example, family proceedings with journalists. And my lords, lastly on this point, just invite you to look at the guidance that's been handed down, and we find this again in volume 3, but 975. There's some practice guidance from the Lord Chief Justice, Open Justice, Remote Observations of Hearings, and I would particularly ask you to consider what's said at paragraphs 14 and 20. 14 is the paragraph that sets out the conditions that the court can impose and the requirement on the observers to identify themselves in some form. Paragraph 20 is a discussion of some of the issues that will arise in court of protection proceedings, so and that the court must consider, so the extent to which
this guidance was given in order to herald the arrival of 85A.
Yes, it's June 2022.
Yes, and 14 is just narrative.
Yes.
But 20 is what you refer us to.
Yes, it's the matters that the court must some of the issues that will arise in court of protection proceedings. So, for example, witnesses being reluctant to give evidence if remote observers are there, and so on. And I would add to that, particularly for court of protection proceedings, the impact that their presence may have on Ps. And again, we'll also have some evidence about that from the court of protection, the Copper survey. Lords, the only other point I wish to make about the procedure is just to refer the court to Dring in the Supreme Court. We don't need to turn it up, but just that three-stage procedure that Lady Hale sets out. The first stage being the application needs to be made, and it needs to say why the person wants to see the document. And secondly, the second stage is that the application must be responded to, and so in court of protection proceedings, the response must look at the harms to P from the position statement being provided, and it may be at that stage that submissions might need to be made about proportionality, but I suspect that's not really relevant for position statements. And cost. And then the third stage is the court balancing those and coming to a decision. And it is important that any procedure encompasses all three of those stages. And as my lords can imagine, stage 2 it can be quite delicate in the Court of Protection and can take a little bit of time sometimes. And my lords, it's, in my submission, really the only effective way of ensuring that P's Article 8 rights are protected. And my lords, the other points to emphasise, and it's already been made, the points have already been made, and I believe it's agreed that it's the decision is one for the judge, not for the parties, and the court and the parties need to consider aspects such as redactions and whether or not the observer should give any assurances as to the matters that we see in the FPR, Practice Direction 12R, about onward transmission, how they're going to store the document, when it might be destroyed. So those are all matters that will need to be considered as part of the process.
I don't at all understand how the destruction of material of this sort that's been sent out to significant numbers of people is a reality.
Well, my lord, it may be that if there are going to be significant numbers of people, the court would say we're simply not willing to do that. The balance, one can't strike a balance that's protective of P's Article 8 rights.
Well, the consequence of that would be that in a sense, the more, I use this word loosely, interesting the case, the less likely it is that there would be the admission of individuals to observe, which seems counterintuitive.
Well, it may be that what one does instead is have a factor in time for a longer opening.
Right.
A longer opening, an oral opening in a case like that, rather than provide position statements.
Wouldn't that be the tail wagging the dog? Which, to just show my use of cliches, is the elephant in the room in this case. That what we're talking about is the protection of P, and as I indicated this morning, anything that requires counsel to do something differently to how they would choose to do it, I just nervous about.
My lord, we, the official solicitor, would echo the concerns raised at the bench and across the bar about the risk of position statements being watered down, particularly for the Court of Protection, because lists are very heavy, particularly Tier 3 judges are dealing with extremely urgent cases sometimes, and they simply will not have had time to look into the documents. They will be relying on position statements.
We go away from the thing that was previously concerning me, which was how you delete how you get people to delete documents months later, when they've long since forgotten about the case. I'm mindful that throwing out ideas at 4 o'clock in the afternoon on an appeal like this is not very good, but people spend some time in drafting chronologies in these cases, and very often the court will be helped by an agreed chronology. Sometimes when we give judgments, we provide press statements. A lot can be achieved by the use of AI, as it were, in summarising complex documents in a way that's, provided it's properly checked, can be extremely helpful and accurate. Is there an answer to the suggestion that, let's suppose, in every case there was an agreed case summary, or something that was no more than a page or 2 pages at most, in which said, this is a case about that. This is what's happened so far. This is what A says. This is what B says. This is what C says. These are the issues. And that will remain constant very largely throughout, although it might need iterative updating if the proceedings go on for any length of time. But as I said, rather than scattering position statements around the World Wide Web, might there not be a place for a 1 or 2 page summary of what this case is about? And then if you want to spend your time listening and observing, you can then build on that. I mean, parties collaborate to produce a chronology. They spend their whole time collaborating to produce statements of the law. It wouldn't take a very great deal to produce a short, neutral account of what this case is about. Might even be entitled What This Case Is About. And it would then not have to do more than give the observer, it wouldn't give the observer the entire building, but it would give the observer the foundation on which they could then understand what the court was concerning itself with. Now, there may be other cases, for example, in which an observer would wish to have more, in which case they could apply for it. Or if the parties couldn't agree about the drafting of the agreed summary, then the court could take a pencil to it and say what it thought should be in the summary. Anyhow, that's just what's running through my mind as a way of dealing with some of these very difficult practical issues.
My Lord, what I would say in response to that is what was quite striking about the witness statement, I think it was the witness statement from Professor Kitzinger, was that what she needed to know in most cases was actually really quite limited. What is the reason that P can't make decisions for themselves? What is the decision itself? And there was something else, and I've forgotten what it is, but it was 3 very limited pieces of information that she was saying she needed to know in each case in order to be able to follow the proceedings. And so it may be that it could be almost as limited as that. But
well, I mean, it's, as I stress, it's not for us to legislate about this, but there is, if the appeal is allowed, there's likely to be a period of time before those who are qualified to set out general practice do so. But it might be that there is a quite simple way of at least giving something, whether it's enough or not would remain to be seen. Anyhow, that's just a thought.
so that was all I wanted to say on the procedure. I raised the issue of court records, whether or not a position statement is a court record, because there's no definition of what a court record is, and if one reads the authorities, it's quite difficult to come to the conclusion that a skeleton argument or position statement is a court record because of the way that they are provided in the Court of Protection, which is usually emailed to the judge, and whether or not they're ever filed is a mystery to which I have no idea what the answer is. And so whether they do actually form part of the record kept by the court is difficult to try and ascertain. I'm not going to go through any of the authorities, but can I just, because of the time, and I've already gone over my time, but can I just ask the court, in their consideration of this issue, just to look at what Lady Hale says in the Supreme Court in Dring about this at paragraphs 22 and 24. She goes back to first principles and sets out, well, what is a record of the court? And we find that at 1205 of the authorities bundle, which is in volume 3. And then also to look at what the Court of Appeal said in particular about skeleton arguments.
Just catching up at the moment.
So 1205. My Lord, what she says is A record of the court is a record kept by the court. It's a long-term record of what's happened. It's for the court to decide what it does and does not keep for its own purposes, as distinct from the purposes of the parties. And practice may change over the years. And she would expect a court to keep a claim form and judgment and orders, but not evidence. Judges continually express a surprise that a skeleton argument or position statement is not often thought to be a record of the court. And the Court of Appeal in Dring has said some quite interesting things about why they concluded it wasn't a record of the court. Again, I won't turn that up, but it's at 1169 to 1170.
But isn't it different in the Court of Protection? Because if a statement of claim, statement of case is a court record, is a part of the court record, if you don't have those
Indeed.
in the Court of Protection, then a position statement is going to be the next best thing.
I'm also, can I be clear? In my written document, I said I was neutral about whether they're court records and put forward an argument as to why I thought they could be considered court records. I now go a little bit further than that and join with my colleagues to say that it would be very helpful if the court can find that they are records of the court or court records, because then we are firmly within Rule 5.9 territory. But I just put the authorities before the court just so that they can ensure that they have addressed them.
These are, just looking at the cases that Lord Justice Hamlin's referring to in the Court of Appeal in Dring, they are cases about commercial cases.
They are.
And for example, he says, skeleton arguments are not part of the records of the court reference a particular decision. They are not documents required to be filed.
Yeah.
So, for instance, we were helpfully shown the directions in this case, showing that they were documents, in this case at least, requiring to be filed.
All I raise is that I'm not sure that they are properly filed with the court,
right.
because they are emailed. Certainly with Tier 3 judges, they are generally emailed to the judge's clerk.
But they would, I mean, certainly in the Rolls building, with the electronic filing system, they're emailed to the judge's clerk, but they're also put onto the central electronic filing system, so that next time when that case comes back, you can go into the file and see what the skeleton argument last time said.
Well, if that's the process in the Court of Protection, then they are clearly filed with the court and they go on the records of the court.
I was careful to say that was the process in the prosecution.
I don't know what the process is, and we don't have any evidence from the court as to that, but the bench will know better than I as to what happens to these documents when they're emailed to the court. May I just turn behind me? I have no more sympathy.
Well, Ms. Scott, thank you very much indeed, and through you can we thank the official solicitor for her intervention. It's been extremely helpful that, although you've kept within a short limit, there's been a lot of reading which we've obviously done and found extremely helpful. Mr. Ratke.
My Lord, I will be very brief. I mean, honestly, I really will. The first is just in relation to Mr. Moss. We do have a line into him and inquiries are being made as to exactly what he's got, because you obviously do need to understand the position in terms of what documents he's got. I don't think I'll be able to get an answer this evening, but we'll of course let you know ASAP thereafter.
Yes.
The second is, it's really a sort of reflection, is that it really came out incredibly strongly in the exchanges with both my learned friends, both of my learned friends, is we've got ourselves into a position where we, to use your lordship's phrase, dropped everything to try and achieve open justice in the context of providing position statements. And what I would really urge on the court in terms of giving the guidance or giving the principles is to really allow the Court of Protection Rules Committee, assuming the appeal is allowed and you send it back to the Rules Committee, to really say, could we take a proper run at this, thinking of all the potential costs and benefits? Because really what's come out very vividly is a whole lot of utterly unanticipated costs, not least because people like Professor Kitzinger are trying to fight the system, along with counsel trying to fight the system, and judges trying to fight the system to try and make this work, and it clearly, in my submission, just isn't working. And the last observation is, I raise this very cautiously, but your lordship in particular was made a specific identification of the timing of what was going on in this case. And I do think it's important that Ms. Sharon, who has been watching very, very closely, has identified that what was going on was that the legal team were having to consider this at the point that the deceased was being extubated and was having to draft submissions and liaise with the family whilst they were at the hospice. I don't make any more of it than that, but it's just simply to emphasise when things are being said about what was or wasn't put in, this was being done at a point of extreme sensitivity when, for obvious reasons, the family's attention was completely elsewhere. I hope it was appropriate just to raise it. I wouldn't have raised it but for the fact that your lordship, Lord Justice Peter Jackson, did identify that as a point. My lords, I haven't got any other points by way of reply, unless there are any other matters I could assist with.
No, thank you very much indeed. Well, we'll look forward to you telling us anything that needs to be said about the situation of Mr. Moss, and to a list of the documents, just so everybody knows what the documents are, and a record is kept of that.
Oh my lord, I'm so sorry. I'm entirely overlooked. I meant to say, I do happen to have, I've got copies of the remote hearings guidance that Mr. Justice Hayden issued in March 2020.
Would you mind sending that out?
Of course, very happy to. Did that? I would warn you, they certainly may give you COVID PTSD because they were written on the 31st of March and they absolutely captured that sense.
My lord, can I just check in relation to the documentation required from me? Close of business tomorrow, would that be acceptable?
Of course. Yes, yes. I mean, it'd be very helpful if you were able to let us have your replies in the next day or two. That would be helpful. And we don't, I stress, we don't wish to make an issue of Mr. Moss's situation.
No.
I mean, he may, for all I know, be taking a continuing interest. But I think we're entitled to know what the position is, and I think he's entitled to say what
completely
his position is about that.
Yep.
All right. Well, can we commend advocates and everybody who has supported them in managing to encapsulate extremely effectively the issues that we have to consider during the course of a single day. We'll obviously take however long we need to consider this, and let you have our judgments in draft in due course. Council will know, but I will just reiterate it for others' benefit. The draft judgments are only to be seen by those who are on the distribution list for those that document, and there'll be a short period of time allowed for you to help us by correcting any typos or obvious errors that we may have made, and to agree a draft order reflecting our decision. Following that, we'll no doubt approve the order, and the judgments will be handed down in the normal way by being placed on the National Archive and on bail, without the need to trouble any of you to return. Thank you again.